We are back live. Well, I guess we're not live. We're pre-recorded, but nonetheless, the show must go on. Today is July 27th, Sunday, 2025. And I am pre-recording this as your host, Dave, a 10-year intellectual property attorney dealing with everything from patents, trademarks, copyrights, as well as trade secrets. And I got a good show for you guys lined up. Now, I'm not going to be able to go live at that time, hence the reason for the pre-record. However, I'm still thinking about you guys. And like I said, the show must go on. I'll probably be kind of on the road at 7 o'clock p.m. Eastern time when this drops. So hence I'm pre-recording the video. Now we have a full show for you guys lined up. The theme of this show today is America's Party. We'll talk about Elon Musk getting sued for trademark infringement for his America's Party. Kind of pull up the lawsuit, go through with it. We'll talk about Donald Trump has been in the news recently for this whole copyright. Do we pay the author, the owners, the copyright owners? Do we not pay the copyright owners? Do we allow these AI tech companies to train or use this copyrighted work from authors and publishers without recourse, without being on the hook for any type of copyright infringement? We'll talk about that. We will kind of do the interview for the week. Repeatabl, Jenny, she's phenomenal, so we'll learn a lot about that. Seems like your boy Damon Dash is back in the news. He was on the Art of Dialogue for interview. So we'll play a snippet of that where it kind of got a little spicy as it relates to a copyright. So we will talk about that. Just some announcements from me. And go check out Got IP ebook. It's in the description section. To the extent that you want to learn about coming up with an idea all the way up to monetizing it, obviously protecting intellectual property. It's giving you a step-by-step playbook or guide on that. So go check out that. These peace, love, intellectual property. I haven't been able to, or I haven't been kind of really pushing them. I'm going to start trying to do that more and more. But peace, love, intellectual property, those shirts, check out the website. That link is in the description. And I always get stopped. Now, today I have on a different one, but this peace, love, intellectual property shirt, I always get stopped when I'm at the gym, when I'm at the grocery store, just out in the community. I went to restaurants and I always get stopped from white people, black people, Mexicans, whatever. And they say, hey, I love that shirt. So go check out that shirt. Definitely go support. It'll serve to the extent that you got a business. It will serve as a kind of good marketing piece for it, because people are going to come up to you and say, hey, what you know about intellectual property? And that's when you can kind of tell them about the business. So go check out that. I guess as we start out here, obviously go hit that like button for the YouTube algorithm, as well as hit the subscribe button to be a part of the IP community, where we do a lot, man. We do current events. We do these interviews. We do these live sessions. Typically it's live, even though it's a pre-recorded today. And what else do we got going on this? And then we do these reaction videos. So that hence is what we're going to talk about in the next section. But definitely go check out that hit the like button for the YouTube algorithm of this video, as well as hit that subscribe button to be a part of the IP community. So buy it now. This is like Amazon's version of Shark Tank. And it's actually more of a game show. You're not necessarily trying to get a deal with the panel members, even though it's 3 panel members. You're really trying to get on the buy it now platform, Amazon's platform, where obviously we know millions, tens of millions, I would probably even say hundreds of millions of people shop on their platform kind of throughout the year. So there are the business owners pitching to get a opportunity to get on the buy it now platform and be able to sell their product. JB Smoove is the game show host, much like Steve Harvey is with Family Feud. And essentially what it is the owner is pitching to a live crowd of 100 people. They can say, yes, they will purchase the product, or no, they won't purchase the product, as the business owners giving their pitch. If they get 10 out of the 100 that say yes, you go into the panel members, which again is typically a 3-team panel member. Jamie, who's a founder of Ring, which was a Shark Tank product, he sold his business to Amazon for $1 billion. So that's where you have that kind of how he has some Shark Tank background, as well as obviously Amazon with the seller of the company Ring doorbell to Amazon for $1 billion. He's one of the, it seems like he's a mainstay panel member, and the other 2 are kind of like a round robin. Somebody is typically on it from the Amazon side, but then you also have a other business owner, entertainer, whatever the case may be. So you need 2 out of those 3 panel members to say they like the product for it to go onto the Buy It Now store and be made available to hundreds of millions of people. So that's pretty much it. This week episode, it was 4 pitches, and I think this skunk skin, and I think that was probably the best pitch in my opinion for a number of reasons. Number one, I love the name skunk skin, and we are talking about trying to sell your product, start a business. Man, marketing and advertising is a big part of that. And to the extent that you can stand out from that standpoint, obviously we know Skunk Skin, or when you're talking about marketing and advertising, is doing with really kind of trademark protected names. The gentleman, I think his name was Matthew, he has a trademark on the term Skunk Skin. So shouts out to him for that. When you think of some of these other big brand names who kind of was able to kind of separate themselves based on the name of the company, even though the product was like, Liquid Death, they're selling water. We all know it's a ton of water companies out there, but Liquid Death just hits differently, makes you a little bit more interested and intriguing to kind of know what's going on. So that's one of them. And then Dude Wipes, which again, I think it was a Shark Tank company that did a deal with Mark Cuban. And again, they're just wipes. And we all know wipes are something, but to say Dude Wipes and be able to kind of market it to dudes, I think they are doing like $300+ million in revenue a year now. And I think a big part of it is on their trademark name. So I think Skunk Skin is going to fall in line with those type products. Like I said, I love the name, and it's essentially an odorless ankle sock or odorless sock, which, especially for athletes or people who, don't have the best hygiene for their foot area, they can wear these socks with confidence that you won't be smelling their feet, or the odor will not go. I know a lot of times people use powders for their shoes or whatever the case may be. But again, that still doesn't, that doesn't resolve the issue or solve the issue. If you're in someone's home and you take your shoes off, you don't have the shoes on, then, you still, if you have stanky feet, then you have stanky feet. But I think Skunk Skin, essentially an odorless socks. I like the name. I like the product. Matthew, he was a young guy. I think they said he was 26. So he recently just graduated college, started the business, which is another thing that I always want to kind of bring up, is make sure as you're starting this business, the sooner the better, the younger the better. You don't have the accountability. You don't have the responsibility as it relates to family, wife, husband, kids, whatever the case may be. When you're younger, maybe fresh out of college or in college for that matter, you have a lot more flexibility and a lot less responsibility so that you can really go all in, try to build a company before you kind of really settle down. So shouts out to Matthew and the odorless socks, Skunk Skin, for starting the business so young, being able to get onto the Buy It Now store. And I think his product is definitely going to be around over the long haul. So shouts out to Matthew on that. So let's get off into the interview of the week. This is Repeatabl. I think she spells the name without an E at the end. Shouts out to Jenny. Go check out that interview that came out this week on the channel, Everything Intellectual Property. We're going to play a snippet from that interview, and then I'll come back and give you guys my thoughts on Jenny and her product, Repeatabl. So let's go. Make sure I have this thing on 1x normal. Okay, there we go. We're ready. Let's go.
Bring these bits and pieces in. I feel ridiculous. I have him sign an NDA, and I'm like, why am I having this guy sign a non-disclosure agreement? Why am I doing this when I just have this idea, right? And now I look back on that version of myself, and I'm so proud of myself for doing that. Number one, for just showing up and here's what I have, right? And then also like not listening to that inner critic that wanted to like discount the idea that I had as if it was something like just stupid and just forget it and this is going to be nothing.
No, yeah, for sure. And even going towards like the signing the NDA part of it, especially when because again, obviously, it's kind of going through the process, but that initial disclosure can be considered a public disclosure if you don't have that NDA or that confidentiality agreement in place, which acts as a kind of, at least in the US here, kind of starts your clock to tick. And if you're in other countries such as like China and like say Germany, it is an absolute bar for you being able to protect your invention by way of a patent. But at least in the US here, they give you that year grace period that starts once you have that public disclosure. However, having that confidentiality or that NDA agreement in place kind of helps out with that. So shouts out to Jenny, man. Go check out that full interview on the actual channel. Some things that, again, first of all, Repeatabl. Jenny, so she did a lot of traveling as a consultant, and again, as women, again, from my understanding, you have to bring your products, your hygiene products, your makeup products, and it seems like, based on what was out there, it was just a better way she thought of doing that. She created Repeatables, what you see on the left hand, bottom left hand, which is essentially you got the travel container or the travel bag, which is a clear bag with a purple outline. But as you can see her, essentially some magnets, some essentially, if you think of like your eyelid, not eyelid, but the what is it called? The contact lens container. It's pretty much similar to that, but it's connected to some type of platform. And I think I want to say it's connected by magnets. And you have, some type of spatula to kind of help you get just what you need to put into the container. She actually got a patent on the product, and she's selling it It's called Repeatabl Travel System. She has a name, Repeatabl trademark. So she's crushing it. And again, talking about just showing up in a video that you heard. She didn't know anything about she was a consultant, travel consultant. She didn't necessarily run a business or know about IP, but she was able to dive in and just show up every day and learn as she go in that particular segment, just talking about NDAs and kind of let me get it off. Bring it on me full time now. She was talking about NDA, non-disclosure agreements. And again, that's going to come into play a little bit more when we talk about Damon Dash later on in this show. However, people just don't appreciate and understand the importance of having an NDA in place, particularly in the U.S. You're trying to, maybe have patent protection that you can get on your invention because it doesn't have that clock start. When you file for a patent or when you disclose your product to somebody else, that 1 year, that your clock starts here in the U.S. where you have a year to file for a patent application on it, or else you're forever barred. And to the extent that you have that NDA agreement in place between you and someone else, whether it's a manufacturer, somebody's helping you out with product development, that does not start that year grace period. So Jenny, in a clip, she was talking about how she felt so kind of just doing way too much, having this person sign an NDA or whatever the case may be. However, she was doing what she needed to do. So shouts out to her on that. I gave you guys my spiel on the importance of an NDA. Like I said, go check out that interview. It was filled with a lot of jewels, a lot of information being dropped, not only on my side, but more so on Jenny's side in terms of kind of starting a business. And she's selling her product now. So you see this is something that she kind of thought in her head, and now she's selling this thing on Amazon, on a lot of different platforms, and she's crushing it. So something simple, really something for the ladies, even though, the man, you can get it too. But I think it seems like it was definitely meant so much more for the ladies. So shouts out to Jenny on her invention, and shout out her for, kind of starting that business. So let's move on here. And I do want to move on to no more theft. And I think this is going to make sense to play this before we get off into Donald Trump's more or less response to it. But it seems like the senators, our congressmen and women are looking out for us. No more theft. And I did more of a full breakdown, so definitely go check out that video for the more full breakdown. I'm not going to go off it in detail here, but as you can see here, the senators introduced a bill to restrict AI companies' unauthorized use of copyrighted works for training models. And this was a bipartisan bill, so this wasn't necessarily a bill that the Republicans only supported or a bill that only the Democrats supported, but this was a bipartisan bill where both the Democrats as well as the Republicans got down on it and saw the importance of it for the American people. Like I said, I did more of like a 10, 12-minute breakdown on this. So this is just kind of more of a quick hit segment. But go check out that full interview. And in the interview, the senator said, hey, the American people are being robbed blind. And as an IP attorney, I would probably agree with him. So if you guys just kind of backing up, and I've been following this, giving you guys the latest and the greatest on this whole AI tech company being able to use copyrights for training their data or training their AI models without being sued for copyright owners. Typically, when you have an artificial intelligence model, which the big tech companies have, you need to train it for it to be able to be, used for good to the masses. And you train it with data. Now, a lot of times that data, at least in this case, that are being used, is protected via copyright, whether it's book authors, whatever the case may be. And they are using that data without permission, and therefore some will say are committing copyright infringement. Now, Facebook got sued as a result of this. Anthropic got sued as a result of this by copyright owners. And that lower court, that district federal court in, I think, California said that, hey, as long as the big companies, the big tech companies, whether it's Meta, Anthropic, as long as they pay for the book or whatever the copyrighted material, then they can do whatever they want with it, even if it is, in this case, training their AI model, and that's not considered copyright infringement. And the authors are pretty much like, no, that's still copyright infringement. And like I said, the court actually ruled on favor of the big tech companies as a result of that. Now that's going to be appealed most likely all the way to the Supreme Court, and who knows what the Supreme Court is going to say to that. However, these senators are getting out in front of it and say, hey, we need to introduce this bill so that companies who are using these copyrighted works to train their AI models, and they're using that unauthorized, they are essentially on the hook for copyright infringement. So the senators are actually trying to look out for you and I as potential copyright owners. So it'll be interesting to see, because like I said, really Congress controls lawmaking, and the courts are just following what Congress is saying. So it seems like Congress is trying to get out in front of this and actually really provide value and provide protection for us as American people. So shouts out to Congress for that. Like I said, go check out that video. In the meantime, your boy Trump has something to say about this. And again, I did a video on this as well. So definitely go check out that video to get more of a full breakdown or analysis. However, I did kind of want to hit on it, I should say, during this live. And pretty much what Trump say, Trump rejects the ideal of paying copyright owners for AI training. It just doesn't work that way. So we heard about the senators in the last segment pretty much saying that, hey, if you're using this copyright material as an AI tech company without authorization, we're proposing a bill such that you're going to be on the hook for copyright infringement. Seems like your boy Trump is saying, look here, tech companies, they can't just pay everybody. And the reasons that he give for it is so like, come on, man, China is the gold standard. He talks about, seems like ultimately it's this arms race of AI between us and China. And in an article, he talks about, hey, China is not doing it. China is not paying their people. And I thought that was laughable because at the end of the day, when did we look to China for the gold standard as it relates to how they treat their people and how they are just kind of, really running their country or whatever the case may be? Obviously, we know China steals. We know they cheat. We know they lie. So all of a sudden, for presidents to be kind of saying or looking at them as a gold standard for something, in particular, this AI stuff, I thought that was kind of laughable. I would love to hear what you guys think about it in the comment section. And he pretty much saying, hey, look, we're not going to require these tech companies to pay copyright owners. And his reason for doing that is, number one, China doesn't do it, which, like I said, I thought that was laughable. But number two, he's making it seem like if we do this, then it's going to slow the AI companies down, and China is essentially going to take the lead, which, man, I get it in terms of making AI be in the right hands, but do you sell out your people as China obviously is doing and would do? Does that make sense, or is that the right thing to do for you to sell out your people? Even in a eminent domain, if the government is taking somebody's land or property, which in this case, this is intellectual property, they still have to pay the landowner a reasonable wage, a fair wage for their eminent domain they're taking of the property. And to the extent that you're going to do it in this case, take somebody's copyrights, then you should at least be on the hook for paying them a reasonable fee for their, for you taking their copyright. So those are my thoughts. Let me know what you guys think in the comment section. Like I said, I thought I like a lot of the things that Trump is doing. However, I thought that this was so far left, so far wrong, and again, really puts you and I as intellectual property owners or future intellectual property owners kind of at risk. Not to mention, it doesn't give you an incentive to actually create copyrights if you know that the big tech companies are going to be able to steal it and ultimately kind of put you out of business without any money. So, hopefully that problem gets fixed, but let's kind of move on. In the meantime, your boy Damon Dash. I'm going to play this video, man, from the Out of the Dialogue. Hopefully they don't give me a copyright strike for this, but we shall see. So in this video, Damon Dash essentially is, recently it came out that he was ordered to forfeit his assets, given his $800,000 debt. He talked about a lot of different things in this interview with Art of the Dialogue, but at this particular segment, he does get off into the debt and kind of how he goes about how does he make sense of it. So this, I think, is interesting. So definitely let me know what you guys think in the comment section, and we're going to stop this throughout it so I can kind of give you guys my thoughts. Let's go.
$100,000 is a W, and anybody that's a real businessman's.
Let me slow it down for you. To normal, a lot of times I watch these things on 2x. So let's go.
World. And I'm like, all right, if you won it, what I lost on was defamation. So the cases were one, and again, I'm gonna say allegedly just in case I say anything wrong, but I directed a movie
get sued
for a favor for a woman called E.W. Brooks in North Carolina. And I directed it, and I went, sat through the edit, and I did it for equity. I said, I'll do you a favor. You can't afford to pay me.
Look, you see how they try to finesse you? I did this woman a favor, and I directed the movie for her because she couldn't pay me. But I got equity, though, but I did her a favor. You're not doing me a favor if you're taking equity. Now, I get it, it's business. You got to negotiate whatever it is that you got to negotiate, but don't tell me you're doing me a favor and you're taking equity on the back end. That's not a favor. That's just a business negotiation or a business deal, in my opinion. Let me know if I'm off.
The budget isn't even what I would get paid. But what I'll do, because you're being an entrepreneur, is I'll direct the movie. I'll use my cameras. I'll use my resources and produce it. And then we'll bust it down. When we finished it, she was actually allegedly aggressive about me promoting the movie, which I did. But once I did that, I got a lawsuit for copyright infringement. Now
look it. This is where the IP come in, and that doesn't make sense. Essentially, we working on a movie together. You got equity, I got equity, and I'm telling you to, hey, make sure you promote the film. And then when you promote the film, I send you a copyright or a cease and desist letter. Like I said, man, I like Dame, man, and I think Dame is a very smart, intellectual person. However, I got something about this doesn't sound right. I'm telling you to promote the film, but then when you promote it, I get a copyright infringement. What were you saying with the promotion? Was it false advertising? Was it copyright infringement? I got to know a little bit more about what your acts in terms of promoting this movie. Because if I'm asking you to promote a movie that you have equity in, by the way, and then when you promote it, I hit you with a copyright infringement lawsuit, that just doesn't make sense. Let me know if you guys think I'm crazy or if you think this situation is smelling fishy already. Let's go.
Let me tell you where the lawsuit came from. So I did the same situation, and what's this dude's name? Tony White. Tony White, who was introduced to me by Dr. What's that dude's name? Damn, I forgot his name just now. But anyway, I was introduced to him, and he asked me to direct a movie, and I'm like, you can't pay me. What's the budget? He said $250. So I said, I'll direct it, use my resources, produce it, my cameras, and we'll bust it down. Or we'll deal with whatever percentage it is. While I'm on the movie set, and I have footage of me directing the whole movie. While I'm on the movie set, I realized that $250 is not being spent and that, he's lying. But because I've used all my resources, I'll pay for the rest of the movie. Another party steps in, Muddy Waters, and they say, well, he lied to me too, but let me pay for the edit so I can stay in. Pause.
So let's break it down. So far, he's saying, hey, the earlier story that he gave, where he took equity, was promoting a film, got hit with a copyright infringement lawsuit, he had shelved that one. He's going to another story where a similar thing has happened where, gentlemen, hey, man, help me kind of get this movie out there. I have $250,000 for it, at least according to Dame Dash. The guy didn't necessarily have $250 that he was spending on it. So Dame Dash stepped in and start kind of spending money in addition to the resources, camera equipment, all that stuff. Seems like another company, Muddy Waters, was also spending money on the edit. So you have three people. You have the person who originally had the film, you have Dame Dash, and then you have third party Muddy Waters, who all are involved somehow in this second movie where they're spending money and resources. So that's where we're at. Let's go.
So we edited. I edited from my house for a year, and we started a new movie, and we had a disagreement about the new movie. So what he did was had the editor send him the edit, and behind my back, he went and copyrighted it. And
this is where I have an issue. Dame Dash has been getting money for way too long, and he's been in way too many of these situations as it relates to ownership to not know at the beginning who owns the intellectual property, who owns the copyright in this case, since it's a movie. Again, you're talking about, okay, the first situation where the chick hit you with a copyright infringement, and then the second situation that ends up turning into a third situation on the third movie, and seems like based on how things were going with the third movie, the person that took the second movie and copyrighted it. And that's a big issue. And again, let this be a learning lesson to the audience. You guys have to know who owns the IP. I have some things that I'm doing, some cool things that I'm doing. I'm in the process of writing books. I'm on the third book that I'll be kind of putting out shortly, kids books, teaching IP. And as well as I have a platform that's kind of on some IP is going to help you out as it relates to you kind of protecting and kind of seeing what's out there as it relates to your IP. So I'm kind of bringing you guys, and this should be done. Both of those things should be done over the next couple months and out to you guys. However, when I'm working with the software developer, when I'm working with illustrators, whoever else, you better believe that at the beginning, I'm having them, they may send a form over for me to sign. However, I'm having them sign a separate form that I'm providing that's saying who owns the IP. Hey, you are only a work made for hire, and all the intellectual property, the trademarks, the copyrights, the patents, the trade secrets that are developed as a result of this work made for hire is owned by me. I'm doing that. And like I said, I haven't had nearly as successful business from compared to Dame Dash. However, I do know that this IP is extremely valuable and that I need to be sure who is owning it from the beginning. To the extent that Dame Dash, they pretty much shot a whole movie is in editing, post-production, and then for the person to go file for a copyright on it, and it seemed like Dame Dash is like surprised, like, oh man, I didn't know you own. So are you telling me that it wasn't clear from the beginning that who's going to be the owner of this copyright, the owner of this movie? Whether or not it was going to be you, whether or not it was going to be her, whether or not it was going to be a combination of both of y'all. These are conversations that you guys have to have.
They started to put new directors on it, or say that other people.
You guys have to have these discussions, these decisions that are made on the front end, so that you are not in these situations where it's okay, who owns what on the back end. So that's kind of my 2 cents. Let's finish off this thing. But again, Dame Dash has been in way too many business meetings, getting way too much money over way too long of a period of time to not know, to make sure it's clear who owns the copyright, who owns the IP from the beginning.
Directed it, allegedly, which is this guy, Josh, and whoever, who never directed. He was like my, either way, they were starting to promote the movie. I called my lawyer and I'm like, yo, handle that. But in the meantime, thinking there's freedom of speech, I say some things. My man Bootsy tells me something that somebody, some wrong information, and I posted it up, and I get a defamation charge as well as a copyright infringement. But they do it in New York, even though it happened in LA. So this same lawyer goes and solicits, I think, and I'm going to say allegedly, goes and gets E.W. Brooks, who I don't recall having such problems with.
That's the first person, E.W.
But then they give me, she represents her for this lawsuit and also the other lawsuit. And they do it all in New York, which means I got to fly all the witnesses to New York. You understand what I'm saying? So, again.
No, we don't understand what you're saying. Like I said, man, you go on these podcasts and you kind of tell your version. Obviously, the interviewer letting them cook, which is probably the right thing to do as well. However, to somebody who kind of knows the details of kind of IP and how things should work, there's way too many holes in her stories. I get it. Seems like it's 3 films. The EW person who was from the first film, it seemed like the attorney, or maybe the other 2 films, was also started to represent her on her gripe against her on the first film. But it seems like a lot of this is stemming from kind of promoting who owns what. Seems like you had at least some equity, at least compared to what you are saying in both that first film as well as the second film. It seems like it's crazy that all these films are being done, being directed, being edited, and nobody understands who is the copyright, the owner of the copyright. Because if it was clear that, hey, E.W. Brooks is going to own the copyright, even though, again, you can have, okay, Tim, I own the copyright, but such and such, we can break down who owns the company. But if both of you guys own the copyright, then you guys can do whatever you guys want to do with it. So if I own a copyright, you can't hit me for copyright infringement with something that I own. But clearly, the people who was working with Dame Dash did not think that he had any ownership in a film, and that's where kind of the breakdown is happening, because he's getting sued for copyright infringement among other things. However, he's saying, hey, I have ownership in this, I have ownership in that. You clearly, they didn't think you have ownership. That's why they sued you for copyright infringement, which leads me all to the beginning that, hey, this could have been avoided if you would have just at the beginning, hey, send over to people, this intellectual property statement and say, make it clear who owns what. Do you own a copyright? Do I own an IP? Do we both own a copyright or other forms of IP? Make sure that stuff is done at the beginning so that you can avoid lawsuits to the best of the ability, as well as other disagreements later down the line. That's surprising that Dame Dash is getting way too much money for a long time to not know 2-3 films in who owns copyrights to this film, that film. We're getting it. Like, it's just bad money, in my opinion, man. Let me know what you guys think in the comment section as we move on to the lawsuit of the week. Let me see what else he's saying before we.
And that was one of the lawsuits, and then another lawsuit from again allegedly, this woman that he took that accused me of sexual, like a sexual thing.
Yeah, I'm not getting off into I'm not getting off into that. So that's pretty much that. Shout out to Dame Dash. Hopefully you guys have some learning lessons in that. Let's go to the interview breakdown of the week. As I was saying before, man, definitely please go check out or hit a like button for the YouTube algorithm, as well as go check out or hit the subscribe button to be a part of this IP community. So it seems like Elon Musk. Let's kind of bring Elon Musk up here really quickly. We all know that Elon Musk and Donald Trump, they were at one point cool. Seems like recently, over the last month or so, they kind of started to butt heads, which a lot of successful billionaires, powerful people do. And Elon Musk seems like wasn't a big fan of the big beautiful bill that Trump think maybe signed into law, around 4th of July, so earlier this month. And Elon Musk went out and said that he was forming a new political party called the American Party. Let's take a look at this. I think this is from Fox News, and then we get off into the lawsuit.
This morning, on the heels of President Trump signing his massive domestic policy bill into law, his former close ally, Elon Musk, announcing the formation of a new political party. Musk, the world's richest person, taking to his social media site X to say, "We live in a one-party system, not a democracy. Today, the America Party is formed to give you back your freedom." Musk, who was President Trump's top campaign donor, has been feuding with the president over the so-called One Big Beautiful Bill, which the nonpartisan Congressional Budget Office says will add more than
So it seems like, based on this One Big Beautiful Bill, let's kind of pull up the lawsuit here. The American Party. So what's the issue with this, Dave? Why is this an issue? Yeah, Elon Musk is coming up with a third political party that's separate from the Democrats and the Republicans called the American Party. What does this have anything to do with intellectual property? However, it seems like somebody owned the trademark to the term not intellectual property, but American Party, so that Elon's formation or use of the American Party for a political party is kind of in the realms of trademark infringement. And Elon Musk was sued by the gentleman for trademark infringement. So we'll kind of take a look at the lawsuit here. Again, like I said, I want to hear you guys' thoughts. This was actually a pretty interesting one. And man, when I do these lawsuits, I try to do them in a way that is adding something to the conversation that I haven't previously talked about. And I do think that this is adding something that, like I said, I haven't previously talked about. So let's kind of go through this one really quickly, and we'll get you guys up out of here. Let me see, man. Let's hide the sidebar. So Roger Cowles is the plaintiff versus Elon Musk, as well as X Corporation, for trademark infringement. They're the defendants, Elon Musk as well as X. And Elon got companies all over. I think Tesla's in Texas. It seems like X Corporation is in Nevada. Thought he had some stuff down in Florida. Let's go here. This is an action for trademark infringement, among other things. It's filed in Jersey. Seems like this guy's seeking monetary damages. Man, did they? I'm glad I did that. They just, what's the name? I don't want to do that, man. I want to do. Yeah, let me see. Here we go. Apologize for that. Here we go. So the action is seeking monetary damages as well as, I'm assuming, an injunctive relief. Plaintiff is commencing this action without delay to minimize consumer confusion. Okay, let's go to the parties here. So Roger is the plaintiff, born in Jersey, has personally borne all expenses associated with the registration and the maintenance of his mark in the American Party. Okay. Defendant Elon Musk, which we'll call Elon, is a well-known entrepreneur and one of the wealthiest individuals in the world. I would agree with that. Kind of giving some more information about Elon Musk that I don't think is necessarily relevant. Well, okay, let's start here. Donations or solicitation of the new political party. So they're talking about his party and existing super PAC, a copy of the homepage. Okay, so this is what Elon Musk, the AmericanParty.org, it seems like is what Elon Musk has founded. FEC records show that the treasurer of American PAC is somebody who was hired by Elon Musk. Musk is sued in his individual capacity and is in his capacity as the sole director of X Corporation. I think X is a privately owned company under the controlling Third Circuit precedent. Now, this is important, so listen up. A corporate officer who personally authorizes, directs, or participates in a trademark infringement may be held individually liable. The service mark at issue, although registered on the supplemental register, is legally protectable under Section 43A of the Lanham Act, which prohibits the use of any word, term, name, or symbol in a manner likely to cause confusion. Musk personally made the decision to adopt and announce the name American Party on July 4th of this month on his personal X account, and the Nevada records identify him as the sole director of an officer of X Corporation, Musk directing the control. So he's essentially saying that to kind of wrap not only Elon Musk into it, but he's wrapping X Corporation into it. And the reason that he's probably doing that, and this is not the most important part of that paragraph, but I'm just kind of explaining to you guys, the reason he's doing that is because I would imagine that Elon Musk has very little in his name. So yeah, you could probably sue Elon Musk as an individual. However, you're probably not going to get nothing because he probably has very little assets in his name, and therefore his assets is owned by his companies, whether it's Tesla, whether it's Starlink, whether it's X, what's the rocket ship company, SpaceX. Those are probably have all the assets, all the money, all the equity in it. So he's trying to rope in X Corporation to it so he can get some money from X as a result of him Elon probably not owning a whole lot. So that's why Roger is suing not only Elon, but X. But the bigger thing is, if you guys caught Elon Musk in the American Party, or Roger's ownership of the American Party was not on the principal registrar, it was on the supplemental registrar. A lot of you guys probably didn't know a simple supplemental registrar existed, and I'm going to go over that a little bit. So you have really kind of two different registrars or databases for trademarks. You have the principal registrar, and again, the supplemental registrar. So typically, when you hear somebody talk about they have a trademark or registered trademark on their logo, on their word, on their phrase, typically 9 times out of 10, it's on the principal registrar. So, which means that, hey, it gets the highest level of protection and it has all these additional benefits. However, to the extent that your mark is not descriptive or distinctive, I should say, then you're not going to be able to get on that principal registrar at the beginning. So you hear me talk, and I'm not going to go off in detail, but a lot of times you guys hear me talk, hey, if you have a suggestive mark, a fanciful mark, and an arbitrary mark, it's considered distinctive at the beginning, and therefore you can get a trademark on it at the beginning. However, if you have a descriptive mark, it's descriptive of the goods or the services, then it's not considered distinctive at the beginning, so you can't get a trademark on it at the beginning. However, it is, you can still use it as a trademark term, and you, over the course of the time when you can kind of show secondary meaning, or that the public has kind of come to understand that this descriptive term is associated with you, your, it's a social identifier to your goods or services, then you can actually get it protected later down the line of a descriptive mark. So the American Party would essentially, Roger is saying in that paragraph is, hey, it was descriptive, so I couldn't get a trademark at the beginning. However, I was able to register it on a supplemental registrar, which again is for non-distinctive marks that over time can become distinctive with continued use and whatever the case may be. So it seems like with Roger, you have this, you have to applaud to him. He's like, okay, even though I can't register it on a principal database to get the highest level of protection, I'm gonna still register it on a supplemental database to get some level of protection and to be able to over time be able to get it, raise the level of protection to that of the principal database. So I would probably say a couple of the big things that are the differences between a principal and a supplemental. Believe it or not, if you register your name on a supplemental database, you can still use the R in the circle. So that's cool. And you can really kind of still sue somebody at that point. Obviously, the hints of Roger suing Elon Musk for copyright infringement, trademark infringement of the term America Party. But some of the biggest differences in it's number one, like I said, it's not a distinctive mark. It's considered non-distinctive, and therefore you don't get that. You're not afforded that higher level of protection. Some of the other things that I would say that is worth mentioning is once a mark safeguards against them trademarks. You can actually use that mark to get other people that come after you their mark rejected, not only on a supplemental registrar, but on the principal registrar. So for example, you register your mark on a supplemental registrar, somebody else comes along and they want to register a mark that's could be considered confusingly similar. You can get you and your mark that's on a supplemental registrar can get their mark taken down or get their mark rejected, not only on a supplemental registrar, but also get it rejected from being on a principal registrar. So it does help out in that you can prevent other people from coming on after you getting a confusingly similar mark registered, whether that be on a principal registrar as well as a supplemental registrar. And like I said, the bigger thing is probably you don't get some of the more protections that are allowed on the principal registrar. But again, over time, you can still sue somebody, hence why Roger is suing Elon Musk in this case. You can still use the R in the circle. So there is a lot of benefit from being on the supplemental registrar that you guys should definitely kind of look into. Let me see here. Let's kind of continue to go off this lawsuit here. X Corporation is liable under the American Party and Commerce in a manner likely could. Okay, so we already talked about that. Let's get down to the nitty-gritty. Statement of facts. The American Party was conceived during the Great Recession. Man, I was just graduating high school around that time. A period in which the major political parties failed to recognize the housing bubble or implement adequate regulation of financial institutions. We applied for our first service mark, American Party in International Class 35 on August 2009. The mark was registered on the supplemental registrar in 2011, so a couple years later, and it gives the registration number. So essentially what happened was they applied for a trademark, and I'm talking about Roger. They applied for, and it's crazy how all these kind of political trademarks end up happening. It seems like it's like a spike during these kind of political moves, either during political, what's the word I'm looking for? Kind of political times, or these, it's time to vote for president or the midterms, whatever the case may be, or if it's a big event that happens. So in this case, 2008, 2009 recession, Roger, it seems like him and a group of guys got together and kind of came up with this American Party as a political party to try to kind of help solve whatever mission that they're looking to solve. Obviously, Elon Musk, 16 years later, he did the same thing. Big, beautiful bill, this hallmark, whatever you want to call it, piece of legislation by Donald Trump, and given some things that Elon didn't like about that big, beautiful bill, he formed this political party. So it's interesting how during like election cycles, as well as kind of big events that happening on the political side, it kind of spur people to kind of come up with these political parties, political committees, whatever the case may be, as well as file trademarks for them, which I love especially when you file trademarks to kind of protect whatever it is that the name of your party, whatever the case may be. So Roger's pretty much talking about they registered or they filed for a trademark in 2009. Seems like it was ultimately rejected, and they went on the supplemental registrar. You got to read in between the lines, but he applied for it, because when you apply for a trademark, you're applying for a trademark on the principal registrar. They're going to reject it to say, hey, you cannot. In this case, I would imagine that they say, hey, this is a descriptive mark, so you can't have it on a principal registrar. And your boy Roger's like, okay, I'll settle for the supplemental registrar. So we have always understood the marks on the supplemental registrar lack the legal presumptions available to the marks on the principal registrar. That's an astute observation by Roger. However, for a newly established political party seeking to build a strong and inherently distinctive mark through use in commerce, the supplemental registrar provides the only available federal registration option. If a mark has not been registered on the principal registrar, it may nonetheless be valid and legally protectable if the public recognizes it as identified claimants, goods, and services, and distinguish them from those of others. So essentially what he's saying is, hey, if it's not, a mark hasn't been registered on a principal registrar, which means that, hey, it's a descriptive mark, then over time you can get trademark rights that are of the same value on the principal registrar. But you have to show that, hey, you've been continuously using it, which I'm assuming that Roger's going to show or you kind of spell out. And you have to kind of show that, hey, the public, the masses, through our continued use, has known the name American Party to be affiliated with us, our company, as a social identifier for what we're doing, not what Elon Musk is doing. So that's essentially what he's saying. I didn't know this guy had an American Party, so that goes to show you that second part of it. So notwithstanding, Roger has acquired substantial common law rights in the mark through 15 years of continuous, exclusive, and public use in interstate commerce. The mark has become uniquely associated with Roger and has acquired distinctiveness among the relevant consuming public. Told you. And a lot of times to get to show distinctiveness among the public, you got to do surveys, you got to show money that you've been spent, show views, whatever the case may be over time. So Roger successfully prosecuted 2 opposition proceedings before the USPTO. I should have kind of pulled those up. So it seems like what he's saying is 2 opposition proceedings before. So I'm not sure if he's saying somebody tried to oppose his mark American Party and he successfully defended it, or if he opposed somebody else's mark for being confusingly similar to his and he was successful. It doesn't kind of show it because it doesn't tell which scenario. Clear evidence of distinctiveness and increasing public recognition of plaintiff mark is reflected on the X platform, where Roger account American Party has approximately 14,000, just shy of 14,000 followers from all 50 states, despite being a private, unadvertised account. A copy of the homepage for the American Party account on X is attached to Exhibit F. So pretty much what he's saying is, hey, we have obviously a page or an account on X that has 14,000 followers. And actually, I'm gonna do this on X. I want to see this because if you ask me, 14,000 is a lot, but is that a lot to be considered distinctive? I don't know. I would probably say no. Let me know what you guys think. Like I said, you ultimately got to do surveys, and the American public at large have to say, hey, the American Party, we know that to be associated with Roger, not Elon Musk. If I had to guess, it seems like now, I don't think that, I think if you ask anybody about the American Party, they're going to say Elon Musk. They're not going to say Roger and this guy. So I think it's an uphill battle from that standpoint. But I do want to I want to see what Elon Musk, if he has something on the American Party. Obviously, there's a couple different American parties out here. Elon Musk, David Spears, move on 18. I don't. So what is this guy? Ameri Party. Let's see here. So he's saying he got just shy of 14,000 people on Instagram. He has a locked profile. And actually, he got 13. I guess he got 13.7. They rounded up to 8. And the posts are protected. So I don't even like that. And I would imagine that Elon Musk and his people is going to point that out. Like, number one, you have a locked account. You talking about you have an account of the people. However, nobody can see it unless they are subscribed or they follow your account. Whereas American Party, I would imagine by Elon Musk, is for everybody, regardless of whether or not you are you followed his account or not. I don't have to follow his account to see his, but this Roger guy, his account is locked on Twitter, so you actually have to be a member to be able to see what it is that he's posting. I think that's going to work against him, in my opinion. But let's continue to see what else he has to say. Plaintiff, Roger Service Market has been in continuous use in commerce for 4 internet websites. So he has some websites. Yes, he has a Facebook. He has an Instagram. Now, whether or not it's distinctive, I'm not sure. But at least like he's definitely been continuously using it, which doesn't hurts. So Roger says for factual background concerning Elon Musk to establish the basis for claims asserted herein. Musk. Okay, so Musk has at various times described his political views as evolving from left-leaning to more centrist. Since 2022, he has publicly expressed support for conservative political movements, including the Republican Party. Okay, Musk currently has an estimated net worth of $400 billion. That's crazy. Just think about that. Let's put this into consideration. Check me out. So Musk has a estimated net worth of $400 billion with 222 million followers on X. So my man just said that he has 14,000 followers on X, or the American Party, his party's social account has 14,000 followers. And Elon Musk has 220 million followers on X. So who do you think X, as well as probably the rest of the world, knows to be in ownership of the American Party? Do you think it's Elon Musk, or do you think it's this guy Roger? Like I said, it's just me. And I get it. Roger's been using this thing for over 15 years continuously, but this is the importance of, to the extent that you can pick a mark or have a mark that's on the principal registrar, you want to do that, because these supplemental registrar marks, they are helpful and they do give you some a level of protection. However, when that level of protection is going up against a billionaire who has the following that Elon Musk has across all platforms, I think it's going to be tough for you to kind of go in court and convince him that, hey, the masses know this name, in this case American Party, to be affiliated with you and not Elon Musk. I think it's an uphill battle for Charles to kind of show that in this case, but let's continue on here. He has an interest in the government party because his company, SpaceX Tesla, are subject to oversight and regulation by multiple federal and state agencies, including the FAA, the NHTSA, essentially all the alphabet community. I shouldn't say the alphabet. Yeah, the alphabet boys. That's crazy. So prior to Musk, July 5th announcement of the American Party, Rogers, through his public X announcement, posted on multiple public messages directed to Musk, asserting his service market rights and cautioning him against. Look, just think about that. You, somebody who has 14,000 followers, that's on American Party. I would imagine that if Roger put it on from his personal account, he probably has less than 14,000 followers. So just think that you're messaging Elon Musk that has over 200 million followers, and Elon to take you serious. I don't know. I mean, I guess it's definitely good to put forth that in a lawsuit, but I would imagine that Elon Musk probably didn't take you serious. So over the years, Musk has run internet polls on his X account where anyone can vote. Again, that's a big part. Anyone can vote. To be able to vote and see your products, Roger, you have to have people have to be a follower of yours, whereas anyone can vote on Elon Musk despite them being a follower or a supporter of Elon Musk. So Musk on July 4th used his personal X account to post a global public poll asking whether an American party should be created. The poll was accessible to users worldwide without geographic or citizenship restrictions. The results of this poll are shown in Exhibit J. 65% of the respondents announced creation of them. Okay, whatever. Musk's announcement of his American Party caused this news to appear in every. Okay, yeah, I would agree with that. Further, some of Musk's followers immediately created multiple social media accounts on X and other platforms, incorporating the term American Party in connection with the political commentary and purported membership recruitment. Further, at least 10 distinct political committees using some variation of the American Party name has been registered. So this guy Rogers pretty much saying once Elon Musk announced the American Party, it seems like that kind of flooded things. That essentially overtook what he was doing. On at least one occasion, Elon publicly refers to his new party as the American Party as shown in the exhibit. In addition, a third-party commentators have referred to Musk's party as the American Party as depicted in the exhibits. Upon information and belief, such references continue to appear and are likely to result in increasing public confusion given the phonetic and conceptual similarity between the American Party and the American Party. Oh, so I guess Rogers is the America Party and Elon's is the American Party. It's still pretty similar phonetically as he's talking about. It is foreseeable that continued use in the former will lead to widespread misidentification of Elon's organization as the American Party, thereby infringing on Rogers' rights. So it seems like Rogers sent the cease and desist letter to Elon Musk in Texas, but it seems like Elon Musk didn't respond. Like I said, it's probably no benefit to blowing off a cease and desist letter, but if you're a billionaire, I can see it happening. Let me see here, man. I'm gonna follow my man's what's the name. Oh man, this guy, look it. I'm finna show my screen. You actually have to, because I put his stuff up on X. And this is why I don't think this is a good argument. Check this out, man. Check this out. So this guy, this is your boy Rogers, who's suing Elon Musk. If you go to follow his, because his account is locked, you see he has the R in a circle, that's well within his right because it's on the supplemental registrar, which is one of the benefits. But when you go to follow, you see at the bottom it says a follow request has been sent to the American Party and is pending approval. So who's going to don't nobody know about your stuff? I'm surprised you got 14,000 followers, but whoever is following you, they got to get your approval. So it's not like everybody just know about you because they have to get your approval for them to actually follow you and see what you have going on. Whereas Elon Musk, he is just open to the world, and the 222 million followers that he has, all of them are probably going to be able to see the American Party. And as a result of that, people are going to associate that with him more as opposed to you, in which you have to actually kind of approve somebody kind of following you, man. I think in that case, I wish I would have saw that before. I think that hurt Rogers' chances tremendously. Nonetheless, let's get back to the lawsuit. So pretty much what Roger was talking about is Elon Musk blew off his cease and desist letter. Roger has continuously used the mark America Party in America in connection with the Class 35 since 2010. So for 15 years, Roger has acquired distinctiveness. That's going to be up for interpretation. I don't think item 32 I don't think that is set in stone. Again, it's good to allege that, but I don't think it's set in stone, especially with only having 14,000 followers. Yeah, 15 years is good. I wanted to see when was the last post, because he could have made a post 2-3 years ago. And if he would have did that, then I know this was a money grab. Just think about that. If you have a social account that has 14,000 followers and you haven't posted in years, then I think this all is a money grab at this point. I actually want to see. I'm not going to do it. I don't want to do any more research on y'all time. But let's go here. I think, 32. I think that's up for discussion. Seems like Elon has begun using the designation America Party, which is confusingly similar to the plaintiff. Defendant's unauthorized use. Elon unauthorized use of the mark had already required protectable status under 1125. Use of the mark began. Elon's conduct is likely to cause growing confusion. I don't think anybody's getting this confused outside of you. I think you are the only one that's confusing the two terms. I don't think anybody else is getting what Elon is doing with the American Party being confused from a trademark perspective than what you have going on with the America Party. That's just me. Let me know in the comments if you agree with me. Plaintiff owns the distinctive America Party mark in Class 35. Like I said, again, I get it. He's using it distinctive. I'm not sure if it's distinctive, if it has acquired distinctive status yet. Roger continuously uses it. Yeah, we already said that. These are the third circuit relevant factors, which these 8 factors the court or 9 factors that the court looks at to determine whether or not it's copyright infringement. I mean, trademark infringement. I keep saying trademark, given the Donald stuff, author stuff, the AI stuff. But the trademark infringement, the court will have to analyze that. But I think even before getting to the likelihood of confusion factors, the court has to determine that he actually has a distinctive mark. Because if your mark is not distinctive, then you're not able to assert trademark infringement. So this is actually big on your boy Rogers thing. And I think he's doing this to try to, if I had to guess, and I could be wrong, but I think he's doing this for a money play. He's trying to get some money out of Elon, because I don't think anybody is thinking that the American party, as Elon Musk has it, is likely a confusion to yours for a variety of reasons that I talked about throughout this thing. And I don't think that probably your mark is even distinct, if I had to guess. And to the extent that the court doesn't find it distinct, then I think that hurts what you have going on at this point. But if it does, the court does find your stuff distinct, then they can analyze this whole the factors for trademark infringement. But I'm not sold that the court has your stuff distinct. It's going to say that your mark America party is distinct. So I think this is a big risk that what you're doing, if I had to guess, but maybe he's trying to get a payday and go from there. So Charles has been and will continue to be irreparably harmed. Okay, and Charles has no adequate remedy at law and therefore is entitled to injunctive relief, which is pretty much saying, Elon, stop using my mark. So that's where we at with it, man. Let me know what you guys think. That was a mouthful. I think that Charles is kind of all in on this one, and I think he's probably Roger's all in on this one, probably trying to get some money from Elon to go away. But again, you have to give credit to Charles for kind of 2008 having an America party and registering that on the supplemental registrar, continuously using it for 15 years, and at least being able to put himself in this position where he could potentially get a payday from Elon Musk. I don't think that the American party, based on having 14,000 followers and nobody knowing you, is going to acquire distinctiveness that he needs to show to be able to get kind of trademark rights in the same way that it's on the principal registrar. But again, reasonable minds can be wrong. Let me know what you guys think in the comment section. Again, please hit that like button for the YouTube algorithm, as well as hit that subscribe button to be a part of the IP community. This will come out pre-recorded, as I have to be on the road later on the night. And I'll hopefully be able to see you guys actually next week. I don't know. We have to see. We have to figure it out. But hopefully you guys enjoyed this one, and I'll catch you guys next time.